Good morning. My name is Lisa Jingaleski, and I'm with the firm Lindabury, McCormick, Estabrook, and Cooper. And today we'll be discussing trends in workplace drug screening. So we're going to begin by looking at trends concerning the use of drugs in the workplace, followed by an examination of the employer's use of drug screening in the workplace and the problem areas or legal issues that they may run into. So let's first talk about drug use in the workplace. Drug use in the workplace has reached an all-time high, the highest rate it's been in 12 years. In 2016, the overall positivity in urine testing, which is the most common form of drug testing, was 4.2%. And that's a 5% increase over to the 2015's rate of 4.0%. And in 2015, that was the highest annual positivity rate it's been since 2004. So we're seeing a pretty big overall jump here. And that's across the board, across all drug types and all testing populations. So what do I mean by testing populations? I have on here that testing populations are generally broken down into the general U.S. workforce category and federally mandated safety-sensitive workforce. And generally mandated safety-sensitive workforce are positions that are designated by the Department of Transportation. And they include positions where the employee safety is exposed or at risk, or the safety of others is at risk. And so generally it involves someone who is operating machinery, for example, aviation, trucking, railroad. It generally also involves positions concerning classified information such as national security. Given this overall increase, let's take a look at some of the more specific trends among individual drugs. So cocaine, first and foremost, we're seeing another upward trend here. A positivity increased to 12% in 2016, and this was a 7-year high of 0.28% in both the general and the federally mandated safety-sensitive workforce. And that's compared to 0.25% in 2015. So we're seeing another increase in the use of cocaine. The positivity rate was high across the board for all forms of testing, including post-accident, pre-employment testing, random testing, and we're going to talk about what those different categories of testing are later in the presentation, but for purposes of this slide alone, it's enough to know that cocaine use across the board has increased. And that's interesting to note because national dialogue seems to really focus recently on marijuana and opiate issues, but clearly cocaine is also continuing this sort of troubling upswing, not only in the general workforce, but in safety-sensitive jobs as well. Marijuana also continues an upward trend. This probably isn't too surprising for most people given the legalization of recreational marijuana use in some states. It increased nearly 75% in the general U.S. workforce. It was 5.1% in 2013, and 8.9% in 2016. So that's a big jump. It also increased in the federally mandated safety-sensitive workforce by nearly 10%. And what I have here is an interesting fact, is that for the first time, Colorado and Washington's positivity rate outpaced the national average. And that's interesting to note because Colorado and Washington were the first states in which recreational marijuana use was legalized. So we're finally seeing it catching up here and actually surpassing the national average. And we're going to look more specifically at the legal implications of employee use of marijuana both inside and outside the workplace later in the presentation. Methamphetamines also continued an upward trend. Methamphetamines are a powerful, highly addictive stimulant, the street name known as meth. But for the purpose of this category, it also includes amphetamine use. And amphetamines include prescription drugs such as Adderall, which is commonly prescribed for ADD. And Together, this grouping increased more than 8% in both the general U.S. and federally mandated safety-sensitive workforce. And really, the rise in the last decade has been primarily driven by amphetamine use, which includes the prescription drugs I just mentioned. And this increase is despite efforts over these past years, these past decade or so, to reduce the production of methamphetamines and to reduce trafficking as well, along with government efforts to improve intervention treatment programs. So despite these efforts, we're still seeing this frightening upward trend. The final two trends I have listed here are heroin and prescription opiates. After 4 straight years of increase, heroin has held steady in the general U.S. workforce and actually declined slightly in federally mandated safety-sensitive workforce. And that's probably the result of the fact that there's been a lot of publicity, a lot of press, which has created awareness of the use of heroin, the heroin epidemic in recent years. Prescription opiate positivity has actually declined in the general workforce. And again, that's most likely the result of the fact that both state and federal authorities have really made efforts to more tightly control the opiate prescribing in the U.S. in order to address the opioid crisis. So keeping these trends in mind, which reflect an overall increase in drug use in the workplace, we can expect employers to want to take certain steps to create a drug-free and safe work environment. And that leads us to our next major topic, which is drug screening. Before employers implement drug screening, they need to be aware of the law in New Jersey governing drug screening, as well as the pitfalls or any sort of legal issues that may arise during workplace drug screening. And I'm going to specifically be talking about 5 overall pitfalls that employers may face. The first pitfall, number 1, is having a vague policy or an inconsistent application of that policy. And first and foremost, before you implement any sort of drug screening, you need to have a policy in place. If that policy is not clear, or if perhaps you have a clear policy in place, but it's not being applied consistently across all the employees, you're going to allow drug use to sneak into your offices. And really when that generally tends to happen is when relationships are formed. Friendships are formed between managers and supervisors and their employees, and they have a more relaxed attitude, or they're willing to look the other way and maybe not apply as strictly to a friend as they would to another employee. And of course, that's going to create issues for the employer down the road. So you need to have a policy in place. It needs to be clear, and you need to make sure that you're applying this policy consistently to all your employers. How do you do that? There's no statutory regulation of private drug testing in New Jersey. What do I mean by that? There's really no law that specifically says what you can and cannot do in New Jersey with respect to drug screening. So until we have something like that, courts are generally looking to one of the most cited authorities on the issue thus far, and that's Hennessy versus Coastal Eagle Point Oil Company. And that's a New Jersey Supreme Court decision from 1992. So it's a relatively old case, but it is still the leading authority on this issue. And what did the court say? They said that there's a clear mandate of public policy that allows an employee who is fired after failing a drug test to bring a wrongful discharge claim against that employer. So what does that mean? It means if an employee passes a drug test, tests positive for a drug test, and certain procedural safeguards are not in place, and we're going to be discussing what those safeguards are, they have the right to then they have the legal cause of action to go about and bring a wrongful discharge claim against the employer. So employers really need to protect themselves and be aware of what needs to be included in these policies in order to avoid this cause of action. And I have here, what's the answer? Clearly outline the circumstances in which applicants and employees will be tested, outline those testing procedures as well as any consequences for violating the policy. And then, of course, have your managers and supervisors trained on the policy and make sure that they're applying the policy consistently. So let's take a closer look at what Hennessy requires or suggests that a written policy should include. Hennessy was first and foremost concerned with an employee's privacy. So I have on here, testing procedures need to provide maximum privacy, as much dignity as possible. So really, as an employer, only conduct those tests that are necessary to determine the presence of the drug that you're testing for. And only disclose the information that comes from those tests to those who need to know, to those on a need-to-know basis only. So supervisors and managers. Because again, as I said, Hennessy was very concerned with protecting employee privacy. You also want to give your employees advance notice of the following: details about how and when that employee will be selected, how the test will be analyzed, and include a warning label, warning about the lingering effects of drug or alcohol in the system. And why is that? For example, marijuana can stay in an employee or an individual system for sometimes 10 days, sometimes later. Same with alcohol. It's dependent upon how much you drink. Your body metabolizes 0.015% of alcohol in an hour. So based on how much you drink, it could still be in your system the next morning, or in the case of marijuana, a couple days later. And if employees are not aware of that, it could lead to them testing positive without having been warned of the lingering effects. And it could be a potential for a cause of action against that employer. So you want to make sure that that warning language is included in your policy. And of course, notify the employee or the applicant of the consequences of a positive test or refusal. And we'll talk a little bit more specifically about what that means later in the presentation. So with Hennessy in mind, most policies should include a general statement regarding the risk of drug and alcohol use. And that can be something as simple as saying that employees that work while under the influence of drugs or alcohol pose a safety risk to themselves and others with whom they work. Just a general statement concerning the risk of drug and alcohol use. You want to identify who is subject to testing, of course. And generally, this falls into one of four categories: the pre-employment stage, when an individual is an applicant applying for the job; reasonable suspicion; random testing throughout employment; or post-accident testing. And again, I'm going to be discussing those categories in more detail later in the presentation. Identify the testing procedure itself. You want to say that the employer is going to obtain written consent prior to testing, that the employer is the one who is responsible for the costs of the testing itself, and that the employee will be compensated at their regular rate of pay during the time when they are submitting to a drug and alcohol test, even if it's taking place away from the office. Confidentiality, we just talked about how important that was to Hennessy. You want to have a statement in there that says all records relating to the employee test results are going to be kept confidential. And you want to keep the results of those tests actually separate from the employee's personnel file. Again, information based on the results of those tests should only be provided to supervisors or those who are on a need-to-know basis. What are the consequences of a positive test? You want to say that you want to include language to the effect that those who test positive could be subject to discipline up to and including termination of employment. Also, job applicants who test positive will have their conditional offers withdrawn. They will no longer be considered for employment. The same is said for consequences of refusal to submit to a test or failure to complete that test. So if an employee or an applicant says, no, I won't take the test, or perhaps they start the process for taking the test and then walk out of the testing procedure. Again, that employee or that applicant could be subject to discipline, including termination, or if you're an applicant, they could have their conditional offer of employment withdrawn. So you want to include that language as well. I apologize for not having that up there on the slide. Employee Assistance Program, that's optional language that a lot of employers are finding themselves including. And an Employee Assistance Program, or an EAP, is generally offered as an employee benefit. So if an employee tests positive for drug or alcohol use, oftentimes employer will offer this EAP program, which provides counseling, perhaps referrals, and other sort of resources to that employee. Acknowledgement, of course, you want to include an acknowledgement page stating that the employee has received the policy, that they've reviewed the policies, and they understand the contents of that policy. And then, of course, include that acknowledgement page in that individual's file. Again, I keep reiterating this, but it's so important. Train your managers and supervisors so they are aware of the policy, the terms of the policy, and so that they apply that policy consistently across the board. So before you can put a policy in place with all the procedural safeguards outlined in Hennessy, you need to know when can these employees be tested. So when is drug testing appropriate? Generally, New Jersey employers allow for drug testing in one of five categories, and I'll explain why I initially said 4. The pre-employment testing stage is when an applicant is applying for the position. Reasonable or for-cause testing, we'll talk about that shortly. Post-accident testing, if there's an accident in the workplace and the employer follows up with drug testing because he believed drugs or alcohol played a role in that accident. Random testing throughout the employment process. And then we also have, just so you're aware, mandated testing. And that's for certain positions, safety positions where people are operating machineries. I have on here drivers, airline pilots, that sort of thing. And that's going to be separated and apart from the general workforce population. So let's start with looking at pre-employment testing. Courts generally condone pre-employment testing because they say that applicants have a lower expectation of privacy, and any expectation of privacy that they have is outweighed at that stage by the employer's interest in creating a drug-free workplace. But, of course, there's always a but, it's important to know that alcohol and testing for legal drugs is considered a medical examination under the Americans with Disabilities Act. What does that mean? Under the ADA, employers may not require employees to undergo medical examinations unless they are job-related or consistent with business necessity. Unlike tests for illegal drugs, tests for alcohol is considered a medical examination under the ADA. So what do you do in those circumstances? Only permit this testing following a conditional offer of employment. Make a job offer contingent upon the successful completion of a pre-employment legal drug, or alcohol test. Important to note that testing for illegal drugs is not a medical examination under the ADA. And of course, just a reminder that any sort of testing programs for applicants need to be in writing, and you need to obtain signed consent forms prior to any testing taking place. The next category is reasonable or for-cause testing. And that's authorized by the courts, but it's not specifically defined. So the Department of Transportation has come forward with a kind of general standard that most courts seem to look to for guidance. And that is that determinations must be based on contemporaneous, articulable observations of employee behavior. And that's going to include their appearance, speech or body odors, how they, I was going to say how they speak, but speech is up there. And basically, it must be based on reasonable suspicion. So the court is going to see whether or not a supervisor or manager looked to objective factors and made a first-hand observation as to the employee's potential drug or alcohol use. And signs that can give rise to suspicion of alcohol intoxication, we're all familiar with them. Clumsiness or staggering, poor coordination, poor judgment, bloodshot eyes, slurred speech, any sort of smell of alcohol on the breath, forgetfulness, and then likewise, same with signs that may give rise to suspicion of drug use. Any sort of dramatic change in hairstyle and clothing, eye movements such as tracking ability are affected, pupil size is altered. Of course, marijuana has its own unique or distinct smell. So these are the type of objective factors that a supervisor or manager will need to observe firsthand in order to give rise to this reasonable suspicion standard. Other signs of substance abuse may include chronic lateness or excess absenteeism, or just not doing a good job. Maybe they're not performing as well, maybe they're having problems with coworkers or colleagues. While these are signs of substance abuse, they don't alone trigger the reasonable suspicion test. In order to trigger that test, the supervisor or manager must observe those factors we just discussed: slurred speech, disheveled looking, smelling of alcohol, smelling of marijuana, those sort of things in connection with this chronic lateness. If all you have, for example, is chronic lateness or just not doing a good job, then you might want to have a discussion about an EAP, have that conversation about an employee assistance program to get that individual back on track. Or perhaps even have a discussion about a fitness for duty examination to see if that individual is capable of performing the essential functions of the job. So with these signs alone, these are the type of conversations you want to be having with your employees. So this slide is just kind of a summary of what a supervisor's role is under the reasonable for-cause testing standard. You want to identify specific observations of the employee behavior and impairments. Then have a conversation with that employee, confront them concerning the requirement to undergo the test. Want to make sure that it rises to the level of reasonable suspicion. If it does, you're going to have a conversation about going forward with the drug testing process. And again, explain the consequences of failing that test, as well as the consequences of refusing to comply with that test, that it can include discipline up to and including termination. And again, always make sure that you get written consent before conducting any sort of drug testing. Pitfall number 2 continued, post-accident testing. What is it? It's exactly as it sounds. There's an injury at the workplace on the job, and an employer believes that alcohol or drug use played a role in that accident. And so they want to have that employee or the employees involved undergo drug testing. Now, the Department of Transportation has said post-accident testing is always going to be acceptable involving a fatality or an injury treated away from the scene. That's if someone has to be taken to the hospital or a vehicle is towed from the scene. But those are specific regulations for certain safety sensitive positions, for example, truck drivers. What about everyone else? Hennessy doesn't specifically address post-accident testing, but really, employers need to apply the just cause standard that we just discussed, the reasonable suspicion standard. And why is that? I have in here that OSHA has made recommendations for post-accident testing. OSHA's recommendations has said that employers cannot just have these blanket policies where in the event there's an accident or an injury at the workplace that they automatically test all employees who are involved for drug testing. That's a general blanket policy that's going to be struck down. And the reason for that is that OSHA says that's going to have a chilling effect on employees' willingness to report injuries, because if they think they're automatically going to be tested for drugs, people may be less likely to step up and say, hey, this is what happened. So OSHA says no blanket policies. Rather, you need to have a situation where there is a reasonable possibility that drugs or alcohol played a role in the accident. So really, again, we're looking back to that reasonable suspicion, just cause, circumstances, and standard that we just discussed. And you're going to apply this again in the post-accident testing. It's going to be a case-by-case determination, but again, you can't just have these blanket policies. It's going to be an individualized suspicion based on the circumstances of that accident. Random testing. Random testing. When is random testing allowed? Hennessy actually forbids random testing unless the employees are in safety-sensitive positions. So safety-sensitive positions are not necessarily defined by Hennessy, but I think we have a pretty good idea of what they include. Positions where the employee or colleagues are and their safety is exposed, perhaps they're operating machinery. I have on here drivers, welders, forklift operators. In those circumstances, random testing is allowed, but generally otherwise, employees are only going to be tested for cause or based on reasonable suspicion. If you do have safety-sensitive employees, then and you are going to be implementing random testing, then there's certain protocols that you should follow. Again, the workers are going to be chosen based on their safety-sensitive function, not just blanket statement based on their title. It has to be, they actually have to be engaged in a position that affects the safety of themselves or others. Everyone's going to be put into the pool. Everyone's going to have an equal chance of being selected in the pool, selected from the pool, excuse me. And again, they just need to follow a scientifically valid selection method. And Hennessy doesn't specifically identify what that is, but make sure you're documenting everything, what the method is, including how the numbers will be drawn, the dates and times of notification, the dates and time of collections. Just have that all specifically outlined if you do decide to implement random testing. Really, the key here with random testing is that there's this element of surprise. That's what makes the program effective. Employees know that they will be tested, but they're not really ever sure when that's going to happen. Generally, however, the random testing should be done on kind of more or less a quarterly basis. Moving on to pitfall number 3, cutting corners. What do I mean by that? Ignoring employee drug use, repeatedly seeing the signs and not doing anything about it, either because you have a relaxed attitude about it or because you're concerned about a friend, you don't want to offend anyone. That's going to come back and create a problem for the employer later on. Opting for the cheapest testing option is also going to create a problem. Obviously, employers are always looking for the most cost-effective way to implement a program or a policy. In this case, drug testing in the workplace. But you can't always go for the cheapest method. You need to know what you're testing for, and then contract with an independent testing facility, which is licensed by the state, to actually test for that specific drug and know what you're testing for. And then, of course, not accounting for cheating. So New Jersey doesn't specifically state what kind of testing is authorized or what type of testing is prohibited. They also don't specify the substances with which tests can be run. Really, only that employers are required to use what's called a scientifically sound drug testing procedure. And in New Jersey, that generally tends to fall into urine or blood testing. Generally, the safest and most effective is the standard urine test because it has the broadest acceptance in the court system. It can also be accepted for the highest number of drugs. And of course, there's the convenience factor as well, that the time it takes to perform is shorter and you get the results back relatively quick. Cheating, however, there's a number of ways to cheat any test. Employees can and have done everything from diluting their sample to purchasing urine to get around a test. So first and foremost, it's important to know how your lab is going about administering its test, and that's going to ensure the least likelihood of cheating to occur. What if someone refuses to take a test? You should have that in your policy. If someone refuses to take a test, they're going to be subject to discipline. They could be subject to termination. They could have their application for the position withdrawn. So that needs to be included in your policy, which we discussed. And when can you repeat a test? New Jersey doesn't actually require employers to provide employees who test positive with a right to confirm testing. However, that's why it's so important that New Jersey employers make sure that their drug testing procedures are scientifically sound in the first place. So employees aren't going to have a right to say, hey, test me again, I don't agree with this. But they do have a right to challenge the initial test if it's not scientifically sound. So sometimes employers do engage in double testing. And why do they do that? At their discretion, to ensure that employees are not suffering any sort of adverse action due to a false positive or a negligent procedure that could result in a cause of action for wrongful termination. So that's why it's so important that you have a procedure in place and you ensure that they are accounting for cheating, they're accounting for everything that they need to determine accurate results. Again, I have it on here throughout the process. Train managers and supervisors, make sure they understand the policy and they're applying it consistently. The medical marijuana card. This is a hot topic right now. I think we have 8 states now that have legalized the drug for recreational purposes. However, marijuana still remains illegal under federal law, which obviously creates confusion over the right to discipline an employee who is testing positive for marijuana use. So the law is still evolving on this topic, and different states have addressed it in different ways. So Colorado, for example, the Colorado Supreme Court, they have a state statute that says you can't discharge an employee for engaging in lawful activity outside of work. That's pretty standard law. However, Colorado said this lawful activity does not include medical marijuana use. And that is because the activity still remains unlawful under federal law. Courts in other jurisdictions have held that employers may discipline employees who test positive, even if the employee has a prescription for the use of medical marijuana. So the case law, as I said, is evolving out there. New Jersey has passed the medical marijuana statute, the New Jersey Compassionate Use Medical Marijuana Act, but there's nothing in that law that requires the employee to accommodate the medical use of marijuana in the workplace. I was just reading about a case in New Jersey that's presently pending where a man who claims he was wrongfully fired because he tested positive for marijuana. This was something he was legally prescribed to ease the pain that he suffered from a medical condition known as Marfan syndrome. I'm not sure if I'm pronouncing that correct, but it's a connective tissue disorder, and he was prescribed medical marijuana to ease his pain. He tested positive after undergoing mandatory testing following an on-site injury, and his employer gave him a choice. They said, either enter rehab or you're fired. And this individual said, no, I'm not going to rehab. I don't have a drug problem. This was a prescription. I have a medical condition. And the employer fired him. And he's now alleging a violation under the New Jersey law against discrimination for failure to accommodate his disability. And he's seeking everything under the sun: compensatory, punitive, front and back pay, attorney's fees, emotional distress. So he is potentially going after this employer for a large amount of damages. So just something to keep in mind, that the case is still pending. So what does this mean for you as employers? Can you terminate someone for engaging in marijuana use? Yes, you can. Do you need to accommodate that employee? Technically, you don't, not until it's federally legalized. But I mentioned this New Jersey case to you so that you recognize the argument that if an employee is being prescribed medical marijuana for a medical condition that arguably falls within the ADA, the Americans with Disabilities Act, or the New Jersey Law Against Discrimination's definition of a disability, then there's an argument that that employer should provide a reasonable accommodation to that employee. So something to keep in mind, if you have an employee who is being prescribed medical marijuana, you may want to sit down and have a conversation with them, provided they place you on notice first and foremost, and determine whether or not you are able to reasonably accommodate that individual in order to allow them to perform the functions of their job. Perfect segue here. Our next slide is the American with Disabilities Act. Both the ADA and the New Jersey Law Against Discrimination prohibit discrimination against recovering or recovered alcoholics and drug addicts, and they require reasonable accommodation. So what does that mean? It simply means that employers cannot take any sort of adverse action against an employee based on his or her status as a recovered alcoholic or drug addict alone. So, for example, if a manager finds out that one of his or her employees is a recovered alcoholic and they decide not to promote that employee, or perhaps they even terminate that employee because they don't want to take any chances, that can be considered a violation of the ADA. You cannot make that determination based on that individual's status as a recovered or recovering drug addict or alcoholic alone. Another example is in a case that's called ADP versus ExxonMobil. That's a New Jersey case. And what was happening there is the employer was requiring recovered alcoholics after they came out of rehab to undergo random alcohol testing. They were trying to ensure that those individuals were sober and they weren't posing a safety risk on the job. The court came back and said, you can't do that. This is a test that is in violation of the ADA because you need a valid reason to follow up with drug and alcohol testing for employees who have completed rehabilitation programs. It goes back to reasonable suspicion. You cannot just say because of their status they should be subject to this follow-up or this random testing. Keeping in mind, however, that there's nothing in the ADA or the New Jersey Law Against Discrimination that protects employees whose drug addiction or alcoholism impairs their job performance. So if the supervisor or manager is noticing certain factors, observing certain factors, slurred speech, all those things we discussed before, that gives rise to the reasonable suspicion standard. And in those circumstances, you can, of course, require that employee to undergo drug or alcohol testing. What happens when an employee self-identifies as a recovering alcoholic or drug addict? Then you should really offer them a reasonable accommodation. And I have here that can include a leave of absence to attend a treatment program. Employees who are not protected, however, are those who are under the influence on the job, because clearly it could be impairing their ability to perform the job. And then they are required to undergo drug testing, in which case they could be subject to discipline. And then also, you're not protected if you come forward only after being directed to be tested. So clearly, if you're directed to be tested, you've exhibited signs to show that your job performance is being impacted. You've given rise to the reasonable suspicion test. If after the fact you come forward and say, hey, I have a problem, no, that doesn't count. You're not going to be entitled to accommodation under those circumstances. However, you still may want to consider a last chance agreement. So while legally you might not be entitled to a reasonable accommodation under the ADA or LAD, it may still be wise for an employer to have that discussion and say, hey, what can we do? Can you take some time off to enter a rehab program? Can we accommodate you in any other way in order to work this out? Another area I should mention just in passing, I don't have it up here on the slide, is the Family Medical Leave Act. That act, of course, requires up to 12 weeks of leave for an employee's own serious health condition. The regulations that implement the FMLA provide that substance abuse may be considered a serious health condition, and an employer may be required to grant a leave of absence for treatment where the abuse is so serious that it requires hospitalization or some other form of continuing treatment. So just another point that I wanted to bring to your attention. So our final pitfall is alcohol, and we've discussed alcohol throughout this presentation. I just wanted to reiterate that it is a problem. I think a lot of people do just associate drug testing with the use of illegal drugs, but alcohol is not something to be overlooked. A lot of times people think of it as simply drinking on the job, but the reality is that the issues come from prior day consumption, and it affects one's ability to perform his or her job. Reports have indicated that the workplace cost of alcoholism has ranged from $33 billion to $68 billion. So it's a much bigger problem than most think, even though it's not necessarily highly publicized and generally considered more socially acceptable. It's not something that should be overlooked by the employer. Again, signs to look for alcohol use: leave-in attendance problems, performance problems, simply not doing a good job. If the individual is having problems with their supervisor or colleagues at work, these of course have to be recognized in connection with those observable, objective factors we discussed: slurred speech, poor memory, alcohol on their breath, that sort of thing. If these factors combined give rise to reasonable suspicion, you of course are going to be requiring your employee to undergo a drug test, which generally is an alcohol test, which is generally administered through a breathalyzer, keeping in mind that testing for alcohol is a medical examination under the ADA. So again, just to reiterate, that has to be, the medical examination must be job related and consistent with business necessity. But of course, when an employer has those objective medical evidence or reasonable suspicion that the employee's ability to perform his job is impaired, that gives rise to the reasonable suspicion testing. And of course, you can require your employee to undergo that testing under those circumstances. And then of course, as a result of that testing, you will either have a discussion with the employee about entering into an employee assistance program, or perhaps subjecting that employee to discipline. And our last slide, just an overview of best practices. Make sure first and foremost you have a policy in place, that the policy is clear, all procedures are provided for and outlined, and that they are consistently applied. Know when you can and cannot test. Don't cut corners, don't try to be cheap, and don't try to overlook cheating. Be careful not to violate the ADA or the law against discrimination. Make sure to engage in that interactive process and have a discussion with an employee about potential reasonable accommodations under the appropriate circumstances. And don't overlook and ignore the realities of alcohol. Thank you for joining me today. My information is cited on the final screen. Should you have any questions, please feel free to contact me directly. Thank you.